Hi, my name is Arati Ganeshan, and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2021-2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas & Co. is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. Today, we have Asees Kaur with us. Asees is a final year student at the West Bengal National University of Juridical Sciences, Kolkata. She is a tech policy enthusiast who wants to explore the impact of technologies from a gendered perspective and within their socio-cultural context. She was also part of a team that presented recommendations before the Joint Parliamentary Committee deliberating the Personal Data Protection Bill 2019. The attempt here was to strengthen India's standards for data security. Delighted to have you here, Asees, and look forward to hearing more about your research on predictive policing systems in India.
My name is Asees Kaur, and as a Meta India technology scholar, I worked on predictive policing systems and the potential for bias in India. Predictive policing systems, simply put, are those systems that use computer or other machine learning algorithms to foresee future crime hotspots, sometimes even likely offenders, based on previous crime data or other information. But why did I decide to work on this topic? And why did I choose this topic to begin with? From Zomato suggesting what we should eat to Netflix recommending what we should watch next, the use of predictive analytic tools have steadily increased over the course of the past few years. However, when these tools are being used by law enforcement agencies and the police, the consequences on our fundamental rights can be grave. Predictive policing systems were used across the USA, and it was constantly criticized for racial discrimination. However, these similar systems have been implemented in India without any safeguards. Therefore, through the course of my paper, I wish to explore predictive policing systems within the socio-cultural context of India's history of policing. The main finding from my paper is that predictive policing systems have the potential to exemplify biases. And how does this take place? This starts right from the beginning in understanding that policing in India has always been discriminatory. But what do I mean by this? When we see the Criminal Tribes Act 1871, it gave a criminal by birth tag to certain communities, tribes, and even the transgender community. As a result of this, these communities were surveilled and over-policed. Once after independence, even when these tribes were denotified, instead they just became habitual offenders under the Habitual Offenders Act 1952 and therefore continued to remain overrepresented in arrest records and first information reports. The Status of Policing Report 2019 also shows that the police are prejudiced against the Muslim community and often refer to areas in which they reside as mini Pakistan in a derogatory manner. Therefore, what is the result of this? The result is that these communities become overrepresented in criminal statistics. And why is this important to understand? This is because we believe that technology is neutral, that algorithms are neutral, but that could not be further from the truth. The bias can creep in through two main methods. The first is through the creation of biased data sets, and the second is through bias in the design of the algorithm itself. When we look at the creation of biased data sets, machine learning algorithms and therefore predictive policing systems are premised on data. However, the problem is that data itself can become the biggest vulnerability of these systems. And this is because the selection and collection of this data are based on human discretion. It's also important to understand that statistics often do not accurately represent criminal activity. And what do I mean by this? Surveys across Indian cities have shown that crimes such as house break-ins, theft, and assault are consistently reported to the police, whereas sexual violence is often not. Therefore, just because something is represented in a criminal statistic does not automatically make it accurate, as the statistics would lead you to believe that sexual assault crimes do not take place in India at all or are significantly reduced than the actual numbers. Furthermore, discriminatory policing against these communities creates questions about the accuracy of data against them. What happens then is that the algorithms uses the data from the arrest records, from the first information reports, to hold and to or to show the police that these areas are in fact high risk communities, even though this data is biased because of the history of policing against them. However, once the area has been deemed as high risk by the predictive policing system, these areas become over-surveilled by the police, and therefore it leads to a larger number of arbitrary arrests. Due to the larger number of arbitrary arrests, these numbers are again put in through arrest records, through then back into the predictive policing systems. And therefore, this creates a vicious feedback loop as these communities continue to be over-policed and discriminated against. Even if we contend that characteristics such as religion and caste are not overtly put into predictive policing systems, other characteristics such as the PIN code, educational status, or the income status often serve as proxies for these communities, and therefore these communities continue to be discriminated against. When we look at the bias in the design of these systems, it raises two important questions. First is who designs these systems. These systems are often designed by upper caste white men that don't understand the nuances of the context of the communities in which these systems will be deployed. Secondly, giving specific data variables greater weight over others could be a source of bias. And what do I mean by this? If we look at the example of Delhi's crime mapping, analytics, and predictive system, this uses calls on its emergency dial 100 helpline to map crimes across the city. However, calls made to an emergency response number are not an accurate indicator of high crime. Further, they do not take into account for the fact that the urban poor and the urban rich interact with emergency response numbers given by the police very differently. Therefore, what happens then is that rich people often are not the ones who are consistently calling these helplines, and therefore these systems end up discriminating against the urban poor. These bias systems are then implemented into society and further exacerbate the bias. Therefore, what are the impact of these predictive policing systems on society? The first is on communities, which I have discussed right now through the creation of the vicious feedback loop that consistently puts them at a disadvantage and discriminates against these communities. However, the impact of this is also felt on the justice system, and there is also the creation of an accountability gap, as we are unsure who to hold responsible for the biased decisions made by predictive policing systems. When we look at the impact on the justice system, we realize that Section 41(1)(b) of the Code of Criminal Procedure authorizes the police to make arrests without a warrant if credible information has been received or reasonable suspicion exists that the person would be committing a cognizable offense. However, the term reasonable suspicion is so subjective, and even this is evident through Indian jurisprudence, where we can see the standard has not been clearly defined. As recently as 2015, the court has held that the power under this section needs to be exercised based on the police officer's discretion, and then the court has no role to play. This then means that it becomes based on the police officer and what he believes to be reasonably suspicious. I therefore contend in my paper that the results of these predictive policing systems can then be used to say that an individual is reasonably suspicious and therefore allow the police to make arrests without a warrant, thereby violating the fundamental rights of the individual. Next, we realize that there is an accountability gap exists because who do we hold responsible if we are discriminated against based on this predictive policing system? The problem arises because there are multiple parties involved, including the designers as well as the deployers of the system. The report by the Artificial Intelligence Committee by the Ministry of Electronics and Information Technology has held that in case there are unintended consequences of an algorithm, the responsibility will be shared by both the designers and the deployers. However, the problem that exists is to be held liable for violating fundamental rights. A company must come within the ambit of state or instrumentality of a state under Article 12. And secondly, the action of the company must be state action, needs to fall within the ambit of law under Article 13. Delving into what this means now, right? When we hold that a company is a private company, is state or an instrumentality of the state under Article 12, the Indian jurisprudence focuses on the control test. However, the companies that are creating these softwares are often private companies that are not under the control of the state and are not funded by the state, and therefore cannot be held to be state under Article 12. Secondly, unlike the United States of America, in India, it's not clarified whether certain actions of a private company can be held to be state action while others continue to remain private. This is important because these companies in India that are creating these softwares are not just creating softwares for the government, but they are also doing private work. And therefore, the entire company could not fall within the ambit of state under Article 12. Even if we contend that the software is created by a government or a government body, or that the company can be held to be state under Article 12, this action needs to fall within the ambit of law under Article 13 to ensure that the government can be held liable for violating fundamental rights under Article 14 and 15. In Australia and even some states within the United States of America, predictive software is often expressly authorized by a legislation. However, in India, we've seen that this is not the case. The only times we even get to know about predictive policing software being deployed in society is because of a police report or because of a newspaper report, lauding the efforts of the police in digitization or automation. And these are the only ways that we get to know about it. Therefore, because it's not expressly authorized by a legislation or an ordinance, it's often difficult to contend that this would fall within the ambit of law under Article 13. And therefore, neither the company nor the government can currently be held accountable under this system. So what can we do next, and what is the government doing? The responsible AI approach for tackling bias is the flagship artificial intelligence initiative by the Niti Aayog in India. The positive of this report is that it notes that AI systems have the potential to be biased, and that this bias does correlate to historic discrimination that certain communities have felt due to the nature of policing in the country. It also notes that anti-discrimination legislation in India doesn't directly cover decisions made by AI systems. The report also goes one step further in noting that even though it doesn't currently cover it, regulating artificial intelligence systems, especially by bodies that have a constitutional obligation to not be biased, would come within the ambit of anti-discrimination legislation within the country. However, this is a problem. As I have just explained, the Constitution of India, which is the only anti-discrimination legislation that currently exists in India, is ill-equipped to deal with AI systems currently. Furthermore, the report notes that more stringent regulations are required for systems that have the potential to violate fundamental rights. Predictive policing systems are clearly systems that have the potential to violate fundamental rights to a great extent. However, the report does not note what kind of regulations will be implemented and does not give recommendations for any such stringent regulations. Therefore, what is my recommendation now? I recommend that predictive policing systems should be promulgated through legislations. In a country wherein so much money and capital has already gone into predictive policing systems, it is unlikely that these will be scrapped immediately. And therefore, I recommend that they at least be promulgated through legislation. Because if they are sanctioned by law, then the government can be held liable, as this would fall within the ambit of law under Article 13, thereby bridging this accountability gap and at least allow citizens to hold the government responsible. Furthermore, it would ensure that there is a carefully defined purpose when this legislation is being promulgated. This allows us to check later whether the system is actually being deployed for its intended purpose. This becomes important when we look at Delhi's facial recognition system that was initially deployed to track missing children, but then later used for broader surveillance purposes. This also results in increased transparency, as when a legislation comes in, there is public consultation. And when systems are opaque, people cannot question deployment decisions. And decisions made by the systems often conceal the discrimination from the victim, as the victim does not realize that they were discriminated against based on a system that was being deployed. Lastly, it's important that no matter what precautions are taken during the creation of the systems, it is essential that these systems are monitored for bias after their deployment to ensure that in case these systems are discriminating against communities, that it is important to put a check on it to maybe roll back the system and take steps to ensure that this does not take place. This leads me to the end of my presentation, and I hope that through the course of these minutes, I've at least been able to understand, or I've at least been able to explain that algorithms and predictive policing systems are not as neutral as we believe them to be, and that automation is not always the answer to everything, especially in the case of law enforcement agencies and predictive policing systems. Thank you so much.
All right. Thank you so much for that, Asees. I think there's so much that's happening on the predictive policing front. We see more and more of these technologies deployed every day. MediaNama has done a terrific amount of work on all these sort of new tenders that come up that look at all these sort of systems as well. So it seems to be the part of the future of policing in India, so to speak. And I think your presentation really was able to clearly articulate why these systems haven't problem, because ultimately they're policing a society that's based on horrific inequalities and social biases. So I think that link was very clear to me. What I found interesting though was, I think the premise of your argument is based on the idea that inequality exists and hence these predictive policing systems replicate that inequality. And of course that's true. But my question is, do you have a bone to pick with predictive policing systems in and of themselves? Forget the inequality argument. Suppose you had this hypothetically pure data set that represented every crime correctly, that, you know, didn't discriminate against a community, that used, you know, up-to-date statistical methods to capture everything well. Would predictive policing systems still be an issue? Or is the core fact that India has bad data the main reason why you have an issue with them? So I'm just curious to know your thoughts on that.
Thank you, Arati, for that question. So I think this is a question that a lot of scholars have been going back and forth with for years now, right? And the question of whether you can ever have clean and fair data sets. And I don't think that you can ever have like the fairest data sets that we would like to exist in any sort of society, right? except for data that has been specifically designed for randomized experiments. Most organically produced data is biased inherently. And this question that you came up with is one that came up in the United States also when Paul released their predictive policing software. They thought it would be free of bias because none of the characteristics that they use within the software overtly mention race or any other demographic information, and therefore they believe that like once they would analyze it, it would be fair, it would not be biased because the data does not overtly mention race at any point of time. However, this was far from the truth because other characteristics in the US, such as PIN code, became a proxy for race. And it was showed that these systems became so biased across the US. And because it was so widely used, a statistic showed that white neighborhoods were a lot less likely to be policed or to show up as high risk rather than black neighborhoods in the United States of America. Furthermore, my problem with predictive policing systems, I think, goes beyond just the data used. It also goes into the design of the algorithm, which can often be biased based on the people that are creating these algorithms to begin with. And also, secondly, the opaque and nature of these systems. These softwares are often proprietary, which creates a black box system. So you don't know what essentially is happening or how these algorithms are using your data to come to a solution. I feel like something like law enforcement needs to be transparent to show individuals how they are being policed in society. And therefore, that transparency for me in its implementation and its deployment becomes essential. I don't believe that technology is the substitute or the fix for everything. And I don't believe that people should be subject to harassment or surveillance based on their proximity to a crime, based on which is what predictive policing systems do essentially. And I think, at least in the United States of America, a lot of cities that were initially very big proponents of predictive policing softwares have rolled back on their use. And Santa Cruz in California has gone as far as to even ban predictive policing systems because they've realized the impact of these systems on society.
Right, thank you for that. And that sort of brings me to another question I had, which is sort of essentially what's the fix here? So, as much as we'd like things to go out of the window, realistically, a lot of the times they end up happening. And digitization is one of those things that sort of, it's like an inevitable march towards total digitization across sectors. So, what comes first? Digitization, if we are going with this hypothesis that it's going to happen, do we need to like, what do you do first? Do you reform laws that are discriminating against people, police laws that have been around for 200 years that continue to discriminate against people? Do you get your systems up and running to make sure, like you said, that you have like an ethically designed system in place? Which is first? Is there like a progression to it? Or is that just the wrong way of looking at the question? Should we just throw these out of the window and fight the government and say, don't do it? Like, what's your take on it?
So I think digitization, like you said, is coming, but I feel like the extent to which you're digitizing makes a difference, right? Digitizing a police record is one thing. Using a predictive policing system to make arrests is another thing altogether. And when you're doing the latter, I think the first thing that has to come mandatorily is police law reform. And I think that has to come first because once you use predictive policing systems in a situation where there are problems with law enforcement, it just further exemplifies the bias, both within the police force as well as outside in society. Because, like I said, reports have shown that the police force itself is biased, right? And when you give them the tools that could further exemplify the bias, there is a need to ensure that reforms take place first. Secondly, when we often, I think, talk about digitization, it comes up in the context of the police force also currently being understaffed and not having enough resources. However, I believe if the police force is already understaffed, and then you give them digital tools such as predictive policing, I think that can further exemplify the bias. And why do I say this, right? Because we've seen that predictive policing systems are often trained on certain kinds of crimes. That means that they are not trained on every kind of crime. So they usually work more for stuff such as property crimes, such as break-in, theft, or even like violent assault. However, what was seen across states in the USA was because police forces were understaffed, they started using this to predict all kinds of crimes, even those such as like drug enforcement or sexual violence related crimes. And therefore, even though these systems are explicitly not created for such kind of crimes, they were used without any safeguards whatsoever for other kinds of crimes, which just skewed results to a very large extent. Therefore, giving understaffed police force these kind of resources, which have such a large propensity for misuse, I don't believe that that's the answer in society.
Right. Okay. Thank you for that. And I'm also curious, when you were talking about the reasonable standards, when you make a warrant without an arrest, you noted that a court had mentioned that, it depends on the police force in that case. Could you just specify which court said that, A? And secondly, what I'm interested to know is, can you give us some examples of what these varied standards look like?
So, like I said, the reasonable suspicion standard in India it's not clearly developed. It is not clearly defined. And the word reasonable suspicion itself, honestly, is a vague and subjective term that's not been defined by the Code of Criminal Procedure. And therefore, it became the job of the courts to end up defining what that means. And by courts over here, I'm only referring to the standards set by the Supreme Court of India. So if we look at it as early as 1994, in the case of Joginder Kumar versus the state of Uttar Pradesh, the court has held that there needs to exist reasonable justification for arrest and a reasonable belief of the person's complicity in the crime. Then we look at the case of Arnish Kumar versus State of Bihar, which happens in 2014. Again, this is the Supreme Court, and it states that the police officers must have a reason to believe that the accused is a perpetrator based on information or other evidence. And the courts have also consistently held that there is a difference between the word reasonable suspicion and other terms used in the Code of Criminal Procedure, such as reason to suspect, because in this case, reasonable suspicion has been qualified by the word reasonable. And therefore, there is that extra standard of care that exists in this case. However, when we look at what is arguably like the most recent judgment in this case in 2015, which is the case of Ramdev Food Products versus the state of Gujarat, the Supreme Court has then held that the power needs to be like the power in this case is based on the police officer's discretion. And after that, the court can't do anything. My problem with this then is that if we look at all three judgments, even if we forget the last and we look at the previous two judgments, the results given by the predictive policing systems can then form the basis of this reasonable suspicion. When we're talking about having a reasonable justification for believing a person is committing a crime, such as that required in Joginder Kumar, the result of the predictive policing system can then become that reasonable justification. When we even talk about the case of Arnish Kumar in 2014, where the court says that there must be some sort of information or evidence to reasonably believe this can then form that basis of that information or evidence, right? And then lastly, the court just goes on to say that it is based on the police officer's discretion then, which then gives the police all the power that they could have needed to make this arbitrary arrest. Therefore, I believe that because of the way the standard has been defined as seen in all these judgments, even though it calls for that need for caution, the words used by the court, such as reasonable belief, reasonable justification, or reason to believe based on information and evidence, the results of predictive policing systems can fall within all of this. The standard then is not high enough to state that like a result of a predictive policing system saying that this person is high risk cannot be used by the officer to then arrest them without a warrant in case they see something fishy. Because it's been seen that as a police officer, right, this also results in a bias in your head. If I am policing or surveilling a high risk neighborhood, even something that like, or a person jumping a fence, right? Maybe in like a low risk neighborhood, I would not immediately view that as a crime. If a kid was doing it, right, I would maybe believe he's just trying to enter his house. Or, versus when I see that in a high risk neighborhood, the reason to believe that an individual is then committing a crime based on the fact that he's in a high risk neighborhood just increases even from the belief of the police officer. So even though they might believe that they're doing the right thing, the result from the predictive policing software can then become the basis of that reasonable suspicion to arrest someone without a warrant. And that's the problem that I believe in diluting or not having that extra standard of care in this idea of reasonable suspicion.
Right. Thank you so much for that, Asees. And this has just been a really sort of illuminating presentation on, what are the ways in which we can safeguard the use of these new technologies, which seems to be happening more and more every day. So thank you a lot for this presentation. If you'd like to read more of Asees's work or watch this video back again, along with the other scholars, please visit our YouTube channel and our website for more information. And thanks again, Asees, and good luck with everything.
Thank you so much, Arti.